May it please the court, my name is Joe Zezatarski. I'm a lawyer in Raleigh, North Carolina, and I represent Charles Robert Barefoot, Jr., who is the defendant and the appellant in this case. Mr. Barefoot's 51 years old. He's serving a 180-month sentence resulting from the trial in this case. He was convicted of 6 counts. This case has a long and tortured procedural history which plays into the first issue that I'd like to discuss with the court. He was indicted in 2005. He wasn't served with that indictment until 2006. There was a superseding indictment later in 2006. And then in February of 2007, the district court judge referred him for an evaluation based on some conduct that occurred at a hearing in the case. He was found not competent due to delusional disorder and remained that way until March of 2011. We came back for a hearing on whether or not he should be involuntarily medicated, and Butner rendered an opinion that Mr. Barefoot had become confident that his condition had remitted. Our expert agreed with that, and the case proceeded from there. In March of 2012, he filed a pro se motion to represent himself, and a hearing was held on that later in March of 2012.
But isn't a trial judge in a much better position than we are to evaluate somebody's competency to represent themselves at trial?
Well, Your Honor, it's an abuse of discretion standard, certainly. It is an abuse of discretion standard.
But I mean, there's a reason for the abuse of discretion standard, and that is that the trial judge was able to actually observe the defendant, and we're not. And that kind of makes all the difference.
Well, Your Honor, I'd ask the court to consider 2 issues on that. The first is, at the hearing itself, Mr. Barefoot's conduct at that hearing in March of 2012 was entirely different than his conduct at the hearing in 2007, 5 years earlier. 5 years. He answered all of the judge's questions. He explained why he wanted to represent himself, and the district court found that his...
Being competent to stand trial doesn't make you really competent to represent yourself in a federal criminal trial.
Your Honor...
And those things, there's a disconnect that jumps right off the page, like that last case of common sense, that seems to me. And then I think Judge Boyle said pretty much that.
Well, Your Honor, this court's holding in Bernard is that the key question is whether the defendant is otherwise able to, who is otherwise able to satisfy the competency standard, may nevertheless be unable to carry out the basic tasks needed to present his own defense without the help of counsel.
This Indiana v. Edwards case
Correct.
really hurts your position because the Supreme Court explicitly refuses to equate competency to stand trial with competency to undertake pro se representation.
They do, Your Honor, but they also point out that, number one, the right to represent yourself is a basic constitutional right. It may not be the wisest thing to do, but it is a defendant's right.
Well, not only is it not the wisest thing to do, but if he'd represented himself and the trial had gone south and the examination, cross-examination of witnesses was a disaster and evidence wasn't properly objected to and the closing argument was a mishmash, we'd be up here on a claim of error that the district court had abused its discretion and not allowing this to go forward on a counsel basis. And I don't like these situations where we get whipsawed either way, because I can see an argument saying, oh, the district judge should never have let this go forward on a pro se basis. Look what happened. It was a disaster. And then we'd be up here on that claim of error. So, you put the trial judge in a situation where he can't win.
Well, Your Honor, that was what happened in Edwards, actually. That was the claim in Edwards. The defendant represented himself, and the claim on appeal was that he shouldn't have been allowed to represent himself. This is the flip of the situation. And again, so
but
here...
they stand for the same principle, which is that competency to stand trial and competency to undertake pro se representation is a very, criminal trial is not a place for amateurs. And you got to know a little bit of, you really got to know what you're doing. And just having standby counsel is oftentimes just doesn't really cut it. And the Supreme Court saying, it seemed to me Indiana v. Edwards was trimming back a little bit on the Ferretta right, I'm saying it's not absolute. It's subject to a district court's trial management discretion.
But, Your Honor, in Edwards, the defendant was allowed to exercise his right. And the point I'd stress to the
But
court
the legal
is-
point, legal principles are the same.
Correct. But the point I would make to the court is here, to deprive the defendant of that right, the standard has to be met. The evidence before the district court has to give the district court a basis under the standard. And what I'd ask the court to consider here is, what evidence was before the district court that when Charles Barefoot was standing in front of the district court in March of 2012, that he could not carry out the basic tasks necessary to represent himself without the assistance of counsel? The court had a year-old opinion from the doctor at Butner that found him competent to represent himself with representation by counsel. That's what the report said. The prosecutor was very candid with the district court judge and said, I haven't talked to Dr. Newman since then. I don't know if what he meant was he can't represent himself.
I think an experienced trial judge, much better position to opine on something like that than a doctor, whether somebody's competent to represent themselves in a federal criminal trial. I mean, it's not a sporting event.
No, Your Honor. No, Your Honor. But again, we're depriving the defendant of his right. And what evidence is there in the record to support that finding? And again, I'd stress to the court the interaction between the district court and the
It's
defendant.
an abuse of
at that hearing.
discretion standard of review.
Correct.
I thought you had better issues than that. I'm surprised you spend that much time on it.
Well, Your Honor, I didn't intend to, and I apologize. I want to
Too
move.
many questions. You start to open these things up, you open up questions too.
I'm sorry, Your Honor. I'd like to move, if I could, to the issue of count 3 and the denial of the Rule 29 dismissal motion, the solicitation to commit crime of violence charge. The evidence in that case came from one witness, Marvin Glenn Gautier. And with respect to that issue, you will recall that Mr. Gautier said that Mr. Barefoot, the charge was that Mr. Barefoot had this plan to blow up the Johnston County Courthouse. According to Mr. Gautier, Mr. Barefoot's plan was that Mr. Barefoot was going to jump in a raft, float down the Neuse River, which goes sort of right next to Smithfield, which is where the Johnston County Courthouse is. He was going to jump out of his raft, carry his bomb, run 3 blocks into the middle of Smithfield, which through the sheriff we established that's how far it was with a map, somehow plant the bomb and set it off without blowing himself up, run back to the raft, and float away. And the government's theory was that Mr. Barefoot solicited Mr. Gautier to assist him in doing this by asking for a ride. The problem we would submit with the government's position is twofold. Number one is there's no evidence of solicitation. If you go to the actual trial transcript, there is literally 4 lines that cover this. After
Gautier testified, didn't he?
Correct. After
Wasn't
Gautier,
he in a pretty good position to know whether he thought he was being solicited or not?
and he said he wasn't sure, Your Honor.
I thought he said that Barefoot was serious.
He said he thought he was serious, but what he said, Your Honor, that was key was, question, now was he asking you to do anything like this? Answer, I think that was in his mind, but he didn't come out and just ask me to do it. He said that's what he had in mind and wanted to find somebody to
That's just a
do
jury
it.
question, isn't it? I mean, it's just something you'd bring up in your close and you'd go over that testimony and and the like. But I mean, it's just a question of sort of how the jury assessed the interaction between Gautier and Barefoot in terms of whether he was trying to bring him along to blow up this courthouse.
Well, Your Honor, I think there's two things I'd ask you to consider with respect to that. Number one is that there has to be some level of solicitation. Solicitation means to ask somebody to do something. That's the common sense. That's what it is. And here, even the government.
Use the word solicit.
No, sir, but he does have to ask. I think he has to ask.
I think the question is whether the jury, you're running up against another tough standard of review.
Correct.
I mean, we look at the evidence in the light most favorable to the prosecution at this stage, on that kind of
And Your Honor, I would just argue that solicit means just that, and that there's no evidence of him asking Gautier to do anything.
These two people had a relationship that didn't just include this one contemplated act. It included the Pettis murder and some other things. And so, you know, they kind of understood where each of them was coming from, you know, and a lot of times when you have two Confederates and associates, you know, the jury could decide, well, you know, a wink and a nod, that told me all I needed to know.
Well, Your Honor, I think that the Pettit murder, for example, is a perfect example. There, Mr. Gautier said, Barefoot told me to go. Told me, go. That's solicited, that's direction.
Right, but there's a history of solicitation of Mr. Gautier here, and the jury was entitled to put this conversation in context. It did not occur in a vacuum. It occurred between two people who had known each other a good bit of time, had collaborated in various ventures in connection with their Klan membership. And the jury had all that in front of it. And the main thing the jury had in front of it was Gautier's interpretation of the conversation, not just in the verbal expression of it, but in the body language and the credibility.
Well, Your Honor, I would just say that in September of 2011, 2001, according to Pettit, according to Gautier, with respect to Pettit, he says Barefoot told me, directed me, and that's what would have happened here if there was a solicitation. That would be my argument. I'm running short on time.
But then I want to just ask you, didn't the defendant speak in detail with Gautier about his courthouse plan?
Your Honor, the detail is on Joint Appendix page 601, the one paragraph of Mr. Gautier's testimony. He says he mentioned something about he planned on doing at the courthouse. He mentioned floating down the river and then goes into the plan that I described. That's the detail. So I would suggest to the court there's not much detail there.
Well, floating down that river and running down 3 blocks and getting back and all that stuff. He told him he had explosives too, didn't he?
Well, he did. He said that his plan, as part of the plan.
I thought he told him he had acquired liquid explosives.
I don't think he had told him that at that point, Your Honor. No, not during this conversation.
And the other thing is, maybe this is the kind of act, maybe the jury said, this is not the kind of act that can be done completely on a solo basis, and that some assistance here would be very much in the defendant's interest. And who did he turn to for assistance? Somebody who'd helped him in the past and whom he felt he could trust. And I mean, the jury could connect all those dots.
Well, it's a question of where the line is, Your Honor. It's a question of where the line is. If I'm generally talking about something, and again, the usual solicitation is, I ask you to go do X. I'm soliciting you to go commit a crime. Here, Mr. Barefoot, according to this testimony, is saying, I'm going to commit a crime, but I need a ride. Will you get me first and drop me off later?
But I mean,
under the government's theory.
I think the question is whether we're going to reduce all these crimes to a magic word, or that there's got to be some kind of magic formulation before you can. The question is whether the totality of the circumstances amounts to solicitation, not whether you actually use the word I solicit, or I ask, or I request.
Well, Your Honor, I would just submit that there has to be some affirmative action by the defendant, and that's the line that I suggest to the court. There's one other point that I do want to try to mention quickly, and that's with respect to the denial of the pretrial motion to dismiss counts 4, 5, and 6.
That's the plea agreement thing?
That's the plea agreement thing.
Were you his counsel
I was.
in the plea agreement?
Yes, sir.
Why did you agree with the provision to reserve the right for the government to use his admissions about violent crimes? Because
I understood crimes of violence did not include the possession or talking about possessing explosives.
Why would you reserve it anyway? I mean, that's it. He's going to come clean. Why wouldn't he just come clean and they give him use immunity? I mean, what? And then And they said, well, we won't give him immunity. We'll give him immunity about everything except crimes of violence. So if he admits to a crime of violence, he can be prosecuted.
Because, Your Honor, they
So
also,
that just encourages the defendant to go in there and lie. I can't imagine two lawyers writing that in a plea agreement.
Your Honor, because they also wanted to talk to him about a murder.
Well, that's a crime of violence.
Correct. He was going to deny everything, and he did deny any involvement in the murder.
But you get people to tell the truth by encouraging them to tell the truth, not hold back because they're afraid of what a crime of violence is. Because y'all didn't even define it. Didn't even attempt to define what a crime of violence is. Do you adopt something in a federal statute, or we have cases every week up here. We're here arguing about what a crime of violence is. Just encouraging litigation.
Well, Your Honor, I never anticipated that this would encourage litigation because I know what I talked about with the prosecutor. And that prosecutor...
The definition of crime and violence is, in the last few years in the federal court system, is in dozens and dozens of cases because we're trying to figure out what it is. And you all put it in a plea agreement. That's where you try to get rid of a case, get it over with. And you all put it in there, and now you're up here. Counts 4, 5, and 6 can't be prosecuted, I think, if they're crimes of violence. Right? If they're not crimes of violence.
Correct.
They can be prosecuted if they're crimes of violence, based on what he said. And he was prosecuted for them, and you're saying, well, they're not crimes of violence, so she shouldn't have been prosecuted.
Correct.
Well, so then we got to decide, I guess, whether 4, 5, and 6 amount to a crime of violence under some definition that you all didn't give each other, as to whether they're barred or not by the plea agreement.
Just if I could respond very quickly, Your Honor. I think the issue, you've honed in exactly, but I would say defining crime of violence was, how was that defined between the parties? And what the government bargained for here was, the government bargained for, we want...
You're going outside the plea agreement by telling us what they bargained for. You got to write the stuff down. Except you should be arguing, I assume, we got to construe it against the government because they wrote it. That's normal law.
Which is what we have in our brief, correct, Your Honor?
Right.
I see my time is up. Thank you.
Thank you. Mr. Wood.
Thank you, Your Honor. Good morning. May it please the Court. Seth Wood on behalf of the United States. The defendant raises 5 issues. We believe all 5 should fail, and we were asking this Court to affirm the judgment of the District Court. I'll start with the last issue that the defendant raised, the plea agreement issue.
Do you acknowledge that you used against him as to counts 4, 5, and 6 information received from him during his debriefing pursuant to the plea agreement?
No. The defendant moved to suppress statements about liquid explosives from that debrief. We did not use...
You prosecuted him on evidence entirely independent of anything you got from him in his debriefing as to counts 4, 5, and 6. Is that what you're saying?
No, Your Honor. Let me be clear.
That's a yes or no.
No.
Did the government independently develop evidence unrelated to anything he said to prosecute counts 4, 5, and 6?
I honestly don't know the answer to that. But
that's a crucial answer as to whether those convictions can stand up in view of the plea agreement.
Well,
depending on whether they're crimes of violence or not. And a couple of them aren't. 5 and 6, I don't think are. Number 4 may be. And if it is, maybe you can prosecute him because of that exception. But if 5 and 6 aren't, you couldn't use against him what he said.
Your Honor, let me...
For any purpose.
Your Honor, respectfully, in terms of the immunity that we've provided to the defendant in that plea agreement, it's use immunity. It's not derivative.
It is use immunity, and I've been using the term use. You could not use that in the prosecution of those counts unless those counts are crimes of violence. If you take position that all 3 of them are crimes of violence, you've got the exception to argue about. Is that what you say, that all 3 of them are crimes of violence?
Let's see. The counts themselves, 5 and 6.
You don't brief that.
Correct. No,
But that's the key as to whether you could use the information.
Well,
counts 4, 5, and 6, which ones are crimes of violence and which ones aren't,
Right.
Or is the answer to all are or all aren't?
No, 4 is definitely a crime of violence.
Four is.
Definitely. But in 5 and 6, I don't want to waive the answer, Your Honor. I'm going to argue that they would be, given the inherently dangerous nature of the
Well,
explosive.
5 is what? Storing explosives.
Right.
So everybody that stores explosives is engaged in a crime of violence
I understand the implication.
or improper storage.
But Your Honor, if I could just turn back to the languages in that plea.
But what definition of crime of violence are you going to use, since you didn't put it in the plea agreement?
We would use the
The one in the guidelines? One in, I don't know what you use.
right. It would have been the common definition of crime of violence at the time they entered into the plea agreement in '03.
Well, could you get back to the question Judge King asked earlier, and that is, to what extent was the evidence obtained during the debriefing used in the course of the prosecution on counts 4, 5, and 6?
Right.
Mainly 5 and 6.
Right. I can say that the statements, and I want to clarify one point. There's an admission about the murder. There are two statements from the debrief that were initially discussed. There was a statement about the liquid explosive, about trading. We already had that liquid explosive in our possession by the time this debrief occurred. Then there was his acknowledgement.
But you didn't make a record on that.
Before where?
In the district court. If you're going to use that evidence, there's what they call a taint hearing, and you got to prove that the evidence you're using is not tainted by the fact that you got it from him, if it was given pursuant to an immunity agreement.
Right.
And you didn't have such a proceeding.
Well, no, Your Honor, but again, and I may just be mixing terms. I'm drawing a distinction between use immunity and derivative use immunity, and that's it matters obviously here. As I was saying, there were two statements made. One was a liquid explosive statement. The other one was a statement about the murder. The liquid explosive statement was not used at trial. The liquid explosive information came in through Messrs. Gautier and Maynard, as well as Barefoot. The son also talked about the hiding of the liquid explosive.
Well, the fact it came in from somebody else doesn't mean you didn't use it against him. If you found the witness as a result of what he said, you've used it against him.
Okay.
It's got to be untainted.
Okay. I'll acknowledge there was no.
I mean, it's diseased. If you used what you got from him after you promised him in the plea agreement, you wouldn't.
I thought there was a search warrant issued before you debriefed him. If so, where did you get that information to seize the explosives?
Correct. The explosives came from Mr. Barefoot's wife. Thank you, Judge. And she provided information to law enforcement. That's an Agent Babbitt's testimony early on in the trial. That formed a search warrant for us. That included a mention of the liquid explosive. I think she specifically said it had been moved from Mr. Barefoot's house to his son's house. And so then that's how the government had these simultaneous warrants that were issued.
Could you speak up a little bit, please?
I'm sorry. That's how the government was then got simultaneous warrants. And so we searched both the defendant's house and his son's house. And we found the liquid explosive then at the son's house. The statement about the murder.
Barefoot told you all in the debriefing that he traded hunting dogs for liquid explosives at least 3 times, right?
I'm not sure about the number, but definitely they traded for hunt with
And
hunting.
you all brought that up multiple times during the trial, including in the opening statement.
Yes. And we did that because we had.
What exception of the plea agreement permitted you to use that?
Well, Your Honor, I think what Your Honor, and I apologize if I'm misunderstanding. I'm interpreting use to mean he says X. If we were to take that statement in trial and try to use it against him in trial, then that would be a problem, and we'd have to get through an
You
exception.
and I misunderstand what use means.
Okay. There's derivative use. We don't have that. And then there would be transactional, which would be very broad. And as we've been arguing, we've been trying to argue that effectively he's asking for a form of
You're arguing that derivative use was permitted under the terms of the plea
No.
agreement?
Oh, no, well, sorry, permitted, yes. It was, because there,
Would you get your act together? I don't know what you're saying to us.
I'm sorry, Your
Please
Honor.
say, come on and make your argument.
Yes, Your Honor.
What are you saying?
We're saying that the plea agreement provision, paragraph 4F, was a use immunity provision, period. I've found case law, in preparation for oral argument, there is certainly a distinction between use and derivative use immunity. There's the,
All right, and which do you say you were using? You were using the evidence only derivatively?
at most, it would be derivative. I'm not
You used
conceding.
none of the actual statements?
We used the murder statement for count 3. Okay, so that came in through
Well,
agent.
that's okay.
Okay, and that came in through Agent Babbitt's testimony. As to the liquid explosive, we had testimony from Mr. Gautier, who helped arrange the transaction. We had, and Mr. Gautier came in. So we had his testimony. We had testimony from Mr. Maynard, who was also present for the exchange in terms of the liquid explosive exchange. So we have independent evidence of this liquid explosive changing hands.
And was that independent evidence obtained without relationship to anything he said?
Right.
I mean, I always understood this use immunity didn't cover derivative use. You had to prove an independent source of the evidence, wholly independent source. That if you were going to use something, you had to prove that you got it entirely independent of any information that came from the defendant's mouth. If you got it pursuant to a use immunity promise in a
Right.
plea agreement.
Okay.
Now, so you and I misunderstand whatever the law is there. We may have to figure that out. But
I apologize for that.
no, you don't have to apologize. You say you think you can use derivatively. You can use it. If he tells you that he and the other guy plan to do something, and you go talk to the other guy as a result of that, and he confirms it, you can put the other guy on the witness stand.
Yes.
So that's
but-
derivative.
No, that's my
And you
understanding.
took his evidence and found the other witness as a direct result of it, and you can use it.
Theoretically, yes. But again, I'm not conceding that we even had derivative situation here. We did have the liquid explosive in hand prior to Mr. Gautier's debrief. Mr. Barefoot's debrief.
Are you making a harmless error argument, or you're not conceding error? And if you're not conceding error, is it because you had an independent source for every one of the facts that was introduced at trial? What are you saying? What are you saying?
I'm trying to say that we had people, not Mr. Barefoot, and people who were not relating Mr. Barefoot's statements at the trial discussing the liquid explosive. That's what I'm saying. So, I'm sorry.
All right, so that would be more of a harmless error analysis, wouldn't it? Wouldn't that be more of a harmless error question?
Well,
If you had plenty of independent evidence, it wouldn't be a question of derivative use and saying, well, we can use questions derivatively. What you'd be saying is, look, we had a lot of independent evidence that related to the storing of explosives and the distribution of explosive material. And that evidence came in abundance on counts 5 and 6. Are you saying that?
I'm not conceding error. I am.
You're not conceding error. You're not arguing harmless error.
No.
He got the same sentence on every charge too, didn't he? I mean, if you lose counts 5 and 6, you still got the same sentence.
Sure. No, absolutely. The harmless error would certainly be an alternative basis. Certainly.
But you don't want to argue harmless error. You abandon harmless error? Does the
No.
government abandon an argument of harmless error?
Goodness gracious, no. I apologize. No, I'm trying to say that, and Your Honor, I interpreted that as, or am I just arguing
You
harmless
arguing
error?
harmless error, or are you not?
I am. Sure. Yes.
You are. Okay, I thought you just said to me a few minutes ago you weren't.
Well, I'm trying to argue both. The harmless would be an alternative ground. I'm trying to make the point that the unambiguous language of this plea agreement it's our belief that we complied with that language because we didn't use any of his statements.
All right, why is this on counts 5 and 6, why is it harmless error?
Counts 5 and 6. It would be harmless because, again, we'd have Mr. Maynard and Mr. Gautier testifying about Mr. Maynard specifically seeing the explosive in Mr. Barefoot's freezer. Mr. Gautier understood that that's where the explosive went as well. So that's count 5, that's the improper storage. Count 6 would be the transfer to Mr. Barefoot's son. Daniel Barefoot testified. He testified that he received the explosive from his father, the package, which turned out to be the explosive, from his father. And so that's, he's the recipient, and he put it in his
Does the
freezer.
harmless error doctrine apply to derivative uses in violation of a plea agreement?
Honestly, don't know. I'm sorry.
What, does harmless error doctrine apply if there's a breach of a plea agreement in terms of derivative use?
Mhm.
If in violation of a plea agreement, there's a derivative use at trial of the statements in the debriefing, does a harmless error analysis apply to save that, or is that something that we just don't expect the government to do no matter what?
Right. We didn't brief the issue, so I would.
What's that?
We did not brief that specific question, and I don't know the specific answer.
Let me ask you this. Maybe I can help you.
Yes.
The statutory immunity that the government can provide to a citizen to secure their testimony, if they do it statutorily, if someone invokes the Fifth Amendment, and the Attorney General and the U.S. Attorney agree that they want them to testify, they can give them statutory immunity, and that compels them to testify. That gets past the Fifth Amendment privilege. And it provides that anything they say can't be used against them. Would you agree with me that since you didn't define what you mean by use in the plea agreement, that probably the best place to look to see what use means would be look at the statute? I think it's 6205 or something of Title 18, been there, to see what the use immunity, statutory immunity, is under that's been authorized by Congress. I mean, that's the only immunity really that that the statute covers is use immunity. You get transactional immunity, you got to get something.
Right.
The prosecutor has to stretch it, but he can only give use immunity under the statute. That is, a court can only order that.
Right. That would be right.
Do you rely on that definition in that statute?
We are not expressly relying on it. I was trying to pull from.
It's not defined in your plea agreement.
Right.
And you say it's a use immunity provision.
We're taking it to mean.
Except that there's a specific exception there for you that you put in, and you must have been a tough negotiator. You got an exception for violent crimes. If he admits to a violent crime, we can prosecute him for it. We can use that against him. But otherwise, it's a use immunity provision for nonviolent criminal activity.
Right.
But I'm just trying to get you to agree that we could use whatever the statute means by use immunity.
Right. If the court believes that it's ambiguous, then certainly that would be something to look to. Yes. The case that I was talking about, there was a decision, the Smith decision from 2006 that's distinguished between use and derivative use. It's not in our brief. I found it in preparation for this argument. It's at 452 F. 3rd 323, and that's. I was trying to find examples of this difference. We talk about use, we talk about derivative, we talk about transactional. And use is the narrowest form of the three. But defendant also raised other issues which we'll rely on in our brief. If I could briefly mention sentencing, we think the district court was correct to group all the offenses for sentencing purposes because there was a continuous and ongoing offense behavior here. So that's 3D 1.2D. We discussed that on page 63 of our brief. We actually discussed both subsections C and D in our brief. And I just want to lead with D because the offense behavior here through all six offenses we view as continuous and ongoing. We did cite one case. I just want to clarify the Mullins case on page 62. That was discussed in terms of relevant conduct. That applies if that definition of relevant conduct kicks in if the offenses are grouped because of ongoing or continuous offense behavior. We believe they're ongoing and continuous for the reasons laid out in our brief. I can address any other issue the court would like. There are three others.
What is the logical connection between the theft of the firearm from his uncle and the explosive materials that would allow the district judge to group it all together?
Right. In our view, the defendant is, all of these things share one common thread, and it's the defendant is using his leadership position, his Klan organization, and the people under it to bring dangerous items to him for his own use. So he's bringing in the stolen guns through Messrs. Daniel Barefoot, Maynard, and Avery. Gautier's helping him. All these people are in his Klan organization. Around the same time, he's acquiring this liquid explosive. Mr. Gautier's helping him acquire that. He's talking to Mr. Gautier around the same time, maybe a month past that, about his plan and trying to recruit him into his plan. The liquid explosive, of course, once it's brought in, Mr. Barefoot keeps it on his property. When he believes that he is being surveilled in June of 2002 by Mr. Avery, one of his Klan members, he tries to move a series of items, and that includes the liquid explosive. The police ultimately find both the liquid explosive and one of the stolen firearms. So that's one of the counts from the conspiracy in Daniel Barefoot's house. So there's an overlap there. If there are no further questions, we ask the court to affirm the judgment of the district court. Thank you.
Mr. Zatarski, you have some rebuttal time, sir.
Thank you, Your Honor. First, Your Honor, with respect to the government's position about the plea agreement, and to address your question, Judge King, about how do we define the crime of violence, let me be crystal clear about our position about this. The government made a promise to Mr. Barefoot, and that promise was not just, we're not going to use your statement. The promise was, you are going to get, the term was, a walk or a free pass for what you told us about bombs or
Now, you're
explosives.
going outside the plea agreement.
Correct.
That's another deal. You all negotiated this plea agreement and you put it in writing, and you're stuck with the writing.
Well, Your Honor, I'd submit that under the cases from this court, we're not stuck with the writing because the government, why was the
You are
crime of...
stuck with the writing, then we might interpret it against the government. Pardon? I'm sorry.
It's an integrated plea agreement. It's explicit that there are no promises outside this particular agreement.
Your Honor, for example, the plea agreement in Harvey, which we cite in our brief, says that the Eastern District of Virginia agrees to not prosecute the defendant further for the conduct constituting the basis of the indictment. Everybody at that time also knew that the defendant was potentially subject to prosecution in the District of South Carolina.
I'm just saying, when you have a plea agreement and it's an integrated plea agreement, and anybody can bring up some kind of oral promise anytime, anywhere, and what it does is it undermines the integrity of plea agreements to try to do that. Why don't you focus in what is the provision in the plea agreement itself that you hang your hat on with respect to counts 5 and 6?
The definition of crime of violence.
All right, what definition?
There is no definition. It's defined between the parties. And the definition between the parties is the promise that the government made to the defendant.
Are we supposed to take a guidelines definition or an Armed Career Criminal Act definition or whatever?
No, Your Honor. I think you take the definition that the government told the defendant that he was going to get a walk for what he told us about bombs and explosives.
That's the oral promise, isn't it?
Well, but that necessarily...
No, I'm talking about the provisions in the plea agreement. Quit coming back to the oral promise, the alleged oral promise. What provision in the plea agreement? Read it out to me.
Well, Your Honor, I hang my hat on
What's that?
I hang my hat on the exception for the crime of violence.
All right, read it.
Well, there's no definition for crime of violence in the plea
Do you
agreement.
agree that count 4 is a crime of violence?
I do not agree that count 4
So
is
you
a crime
don't
of violence.
agree that any of them were, so you say 4, 5, and 6 are all
I would
nonviolent?
I would say that count 4 is akin to a felon in possession of firearm, which is not a crime of violence. Here, it's simply possession. It's illegal receipt.
What you do here is it's just like a statutory term that's undefined. And if you don't have a term in the statute that's undefined elsewhere in the statute, and here we have an undefined term, it's not defined elsewhere in the plea agreement, then you take a common sense look at it. And the Supreme Court's clear about that, undefined terms. You take a common sense view of it. Receipt of an explosive with intent that it be used to murder or injure persons or property. It doesn't seem to me a whole lot of, I don't have to make a leap to determine that if you're taking an explosive with an intent that it be used to murder or injure someone, that doesn't trouble me finding that that's a crime of violence. Now, six is a closer case, and 5 is an even closer case. But I want to know what your argument is. Is it that the derivative use was made of statements in violation of the plea agreement? And if so, what statements were used? What particular statements were used? What particular provision of the plea agreement did they violate? And why was it not harmless error?
Your Honor, I know you told me not to go back to the oral promise, but
I don't know. I don't want to hear about the oral part. I want to hear about a provision of the plea agreement that was violated, because that was negotiated between the parties.
And Your Honor, I would say that that is a provision of the plea agreement between the parties.
Well, it's not. Assume you're wrong on that the plea agreement is what's on the paper. Accept that.
If I'm wrong on that, Your Honor, I think that you have to use a common sense definition of the term crime of violence.
Definition, not a statutory definition.
Correct.
Guidelines definition.
Correct, because this
Okay.
is an undefined term of the plea agreement.
And assuming you are right on a couple of the counts, like 5 and 6, where he got concurrent sentences, why isn't that harmless error?
Well, I think practically speaking it would be, because he got concurrent sentences. I would concede
That's
that, Your
what I'm
Honor.
getting at. He got a concurrent sentence.
He
And
did.
if we vacate the convictions and sentences on counts 5 and 6, if we were, hypothetically, that wouldn't help him a bit
Correct,
when he ever got out of penitentiary.
correct. In terms of the practical effect of it,
And
that
what if
wouldn't
we
help a bit.
vacated, you also raised count 3 for lack of evidence, he still wouldn't help him any, right?
Well, Your Honor, I think that would affect the guideline calculation,
It might affect the guideline.
even under the government's view.
All right, counts
Yes.
5 and 6 wouldn't affect the guidelines.
I don't think they would, Your Honor. No, I don't think they would. And very quickly, to jump to the guidelines question, which came up during the government's presentation, it's important to note that what the district court hung the connection to allow all of this grouping on was testimony about a pipe bomb that somebody testified about seeing Mr. Barefoot set off in his yard and possess in his home. And again, I would simply go back to the terms of relevant conduct, which are that the gun counts of 1 and 2 and the other counts of 3, 4, 5, and 6 can only be grouped if 3, 4, 5, and 6 were done during the commission of the offense, in preparation for that offense, or in the course of attempting to avoid detection or responsibility for that offense. That offense being the stolen gun charges. And the possession of the pipe bomb simply had nothing to do with commission of the stolen gun offenses, in something occurring in the course of the stolen gun offenses, or some effort to avoid detection or responsibility for those offenses. So I would say to the court that the basis that the district court relied on to group those together by the very terms of relevant
I don't know
conduct.
why you say that they're all unconnected. What he did is he was grouping the gun counts and the explosives counts, and they were all connected to the KKK activities, weren't they, and violent plans. In the defendant's position as head of the KKK chapter. They all, whether he was going to be doing it with guns or whether he was going to do it at explosives, the point is he was using violent means to achieve the KKK's goals, in which he was a very prominent member.
But, Your Honor, both the probation office and the district court adopted the PSR, which talks about possession of these pipe bombs as being the basis to link this all together. An argument would be that it's not relevant conduct, so they can't link it all together. I see my time is up. Thank you.
All right, we'll come down and greet counsel, and we will first adjourn court.
This honorable court stands adjourned sine die. God save the United States and this honorable court.